Straight ahead on Law and Crime Daily. Defense attorneys for convicted wife killer Scott Peterson accuse a juror of not disclosing she was a crime victim while pregnant. Could this be grounds for a new trial? The evidence used against the Colorado father accused of murdering his son. See key blood and forensics in the Mark Redwine trial. Breaking down Derek Chauvin's sentence for the murder of George Floyd. How Judge Peter Cahill reached 22.5 years and what's next for the former police officer. Robert Durst fires back at prosecutors.
I am not seeking sympathy from the jury.
The head of the billion-dollar real estate company Durst organization takes the stand against his own brother. Crime Daily, I'm Brian Buckmeyer along with Terry Austin. Scott Peterson's lawyers filed new court documents claiming a juror lied about being the victim of a crime while she was pregnant. Angela Levy is here with how this could result in a new trial for one of America's most well-known inmates.
Brian, juror Rochelle Neese was nicknamed Strawberry Shortcake during that months-long trial. Peterson's lawyers say Neese lied about being a victim of a crime when she filled out her juror questionnaire. Now, Neese was juror number 7 in the trial that led to Peterson's conviction for the murder of his wife, Lacey, and their unborn son in 2004. Well, court documents reveal that Neese had been beaten by her boyfriend in 2001. Prosecutors have said in prior court filings that Neese misinterpreted the questions on the questionnaire. Neese had also sought and obtained a restraining order against her boyfriend's ex, fearing some sort of harassment after that woman slashed her boyfriend's tires. Neese also wrote several letters to Peterson in prison in 2005 and 2006, in which she questioned him about Lacey and Connor's deaths to try to get him to confess.
So we caught a number of stealth jurors, but we did not catch Ms. Neese. And, you know, it ruins the whole process. And not just for Scott Peterson, but for all defendants. When you have a preconceived notion about guilt or innocence, there's nothing wrong with that. That's fine. You know, you're welcome to your opinion, but you shouldn't get up and lie and get on a jury to hurt that person.
Now, the judge in the case has said she will make a decision soon about whether she's going to have an evidentiary hearing on this juror issue. If that happened, Rochelle Neese would be called to testify and subjected to questioning by both sides. Now, Peterson will be back in court in August, and the judge has also said she will make a decision this year about whether or not Peterson gets a new trial. Brian?
Thanks, Anjanette. Joining us today is defense attorney Sue Ann Robinson and Terry Austin. Sue Ann, looking at the actions of this juror, Strawberry Shortcake as she's been called, how big of a deal is her non-disclosure in terms of getting an impartial jury?
I think the issue is her actually, if she misrepresented purposefully, then obviously she's lying. And that's really what the big deal is. I personally don't think that her having that experience necessarily makes her unable to be impartial. I think the issue and the appellate issue is going to be if she's lying, if she lied, if she didn't answer, if she purposefully was trying to be a stealth juror. That's going to be a big deal on appeal for Scott Peterson.
Yeah, it makes sense, because then if she told the truth, both sides would have been able to use a peremptory challenge or maybe ask further questions, could have played out a little differently. Terry, what do you expect the judge to decide, a retrial or hearing?
Well, I think what she should do is to have a hearing, because as Sue Ann pointed out, the real question is whether or not this juror was lying. And the judge specifically said if the motion papers are strong enough, she's going to make a decision as to whether or not there should be a retrial. But if they are not strong enough, she is going to have an evidentiary hearing. And the hearing would obviously include this juror. So under oath, she would have to answer questions as to what she said during the voir dire. And if, in fact, she was lying, then I do think that might be a grounds for appeal, because everyone obviously is entitled to a fair and impartial jury.
Yeah, well, it'll definitely be an interesting hearing if that does happen. And Jeanette, isn't Scott Peterson also facing a resentencing?
Yeah, he definitely is, Brian. This is an interesting case because we have these kind of two separate issues. The resentencing, since the California Supreme Court sent the case back and said there were errors and there needed to be a resentencing. The prosecution said they will not pursue the death penalty this time around, so it will automatically be life without parole. However, Peterson's lawyer, Pat Harris, is saying, well, but we have this other issue about the juror misconduct, so there may be a whole new trial. So there's this whole thing about, does he get a new trial? Do we resentence him to life without parole when there's the possibility that he gets a new trial? So there's a lot going on with the case.
Yeah, a lot of moving pieces. We'll see how those all fit in. Of course, we got to wait to see what this whole jury question is. Maybe that's what the judge is waiting for, decide that before deciding the sentencing. Thank you all. Now to other top legal news. Marilyn Manson has reportedly reached an agreement for him to surrender to police in an assault case. The provocative musician is known for his controversial stage personality. Police in New Hampshire accused Manson of committing assault against a videographer in August 2019. In a statement to Law and Crime, the Guilford police chief says Manson plans to surrender in Los Angeles. Manson also faces multiple sexual assault allegations, including those by his former fiancée, Evan Rachel Wood, and actress Esme Blanco. Britney Spears has reportedly escaped to Hawaii days after speaking out in court regarding her conservatorship. In a passionate statement, the pop singer requested an end to the lengthy conservatorship, under which her father controls many aspects of her life, including finances. Not long after her plea, Spears was spotted walking the beaches of Maui with her boyfriend. Now to Florida, where the man accused of shooting a police officer in the head was arrested in Georgia with the officer's own handcuffs. The officer was investigating a suspicious vehicle when the driver, 29-year-old Othal Wallace, allegedly shot the officer and took off. Wallace was found after a 56-hour manhunt hiding in a treehouse east of Atlanta at around 2:30 a.m. Saturday morning. Police say they also found an array of firearms and ammunition. The Daytona Beach police chief shared pictures of the arrest, showing Wallace in the injured officer's handcuffs and expressing his excitement of catching the suspect. Still ahead on Law and Crime Daily, Derek Chauvin sentenced to 22.5 years in prison. But what's next? But first, we take a black light to the trial of Mark Redwine. The prosecutor illuminates evidence in the murder of a 13-year-old boy next. Welcome back. The jury in Mark Redwine's trial hears about blood and DNA found in the Colorado man's home. Law and Crime's Anjanette Levy is back with the testimony.
In several locations in Mark Redwine's living room, and it will be up to the jury to decide what that DNA means as it relates to Dylan Redwine's death.
A crime scene investigator examined Mark Redwine's home in 2012 using luminol and a black light. Several areas lit up, showing possible blood. Samples were sent to a DNA analyst.
Love seat couch cushion from room B that were positive for the presumptive presence of blood in the laboratory. There were swabs that were collected from the floor under the rug near the coffee table of room B.
Rebecca Strutt tested the areas that were swabbed from the love seat, coffee table, and floor under a rug in Mark Redwine's home.
The DNA profile from the swabs from the love seat of the south cushion of room B, item 2.1, matches the DNA profile developed from Dylan Redwine.
But another area had a mixture of DNA.
The DNA profile that was developed from the swabs from the floor under the rug/coffee table of room B indicates a mixture. Corey Redwine and Dylan Redwine cannot be excluded as potential contributors to this mixture.
Mark Redwine's attorney seized on the fact that a mixture of DNA was found to cast doubt on what the DNA in Mark Redwine's home could mean.
One thing DNA cannot tell you is who contributed the blood to that mixture, correct?
That is correct.
Meaning your analysis can't say Corey definitely contributed the blood to this material, correct?
That is correct.
Prosecutors tried to eliminate any doubt that Dylan's blood was found in that living room.
There were multiple locations in that room where they tested presumptive positive for blood.
And the prosecutor also asked the DNA analyst whether or not Dylan's blood was found in several locations in that living room, and she said it was. Brian?
Let's bring back defense attorney Sue Ann Robinson and Terry Austin. Terry, where do you think the defense was going with their argument of mixture of blood, and do you think it was successful?
You know, Brian, the job of the defense attorney is, as you know, to raise some reasonable doubt, and that's exactly what he was trying to do. But the DNA expert was pretty definitive here. She said without a doubt, she confirmed that multiple locations tested positive for a presumption that it was Dylan's blood. So the fact that another area might have a mixture of Corey's blood and his blood doesn't really mean as much because they are siblings. And hopefully the jury will understand that most of the blood in that room was Dylan's blood, and that does indicate that there was some sort of violent scene at that location.
Now, Sue-Ann, I'm guessing that's what the prosecution is going to try to say, blood all over the living room. But how do you think the prosecution can piece that together in the summation to kind of paint a picture for the jury?
I think the prosecution has a little bit of an obstacle in the fact that obviously the mixture creates a reasonable doubt, as Terry pointed out. I think it's their job to almost reconstruct the crime scene for the jury to the extent they can based on the evidence, to kind of give them an idea, like you said, about the fact that it must have been a violent scene for the decedent's blood to be splattered different places. And possibly, if the evidence permits, they could say that there was an attempt to clean up, which is why it's not pooled in areas. Because sometimes with luminol, you can tell if there was a removal in some areas. So I think it's going to be up to the prosecution to really dig in with their expert witnesses' testimony and take out the pieces so that in summation, they can put together the actual altercation that they're alleging led to the death.
Makes sense to me. And Jeanette, the DNA analyst, was also asked about what might happen if someone was punched in the face or hit in the back of the skull, right?
Yeah, she was asked that by the prosecutor, and whether or not that would leave a large amount of blood on the fist of the person who punched the other person. And she said not necessarily so. And she was also asked whether or not, she gets large quantities, pounds of DNA into the crime lab to analyze. And she said, no, she doesn't. Usually the samples are very small.
Yeah, very small, just picograms as they call them, in measuring blood and DNA. Thank you all. Coming up on Law and Crime Daily, Robert Durst stands up for himself, pleading with a judge for help. Plus, a cryptic message by Derek Chauvin as he is sentenced for the murder of George Floyd. What he said and didn't next. Welcome back. We're now learning more about a judge's decision sentencing former Minneapolis police officer Derek Chauvin for the murder of George Floyd. Judge Peter Cahill sentenced Chauvin to 22.5 years in prison. The time is based on the top charge Chauvin was convicted of, second-degree unintentional murder. Judge Cahill authored a 26-page sentencing order, writing in it that he departed from the state guidelines of a 12.5-year sentence because he found two aggravating factors: that Chauvin abused his position of trust and authority, and that he treated Floyd with particular cruelty. Under Minnesota guidelines, Chauvin will serve 2/3 of his sentence, meaning he will be released from prison in 15 years. But he's also facing federal civil rights violation charges. Chauvin is due back in federal court for his arraignment in September. Back with us is my guest, Sue-Ann Robinson, who's of counsel for the Benjamin Crump Law Firm, the firm representing George Floyd's family. Sue-Ann, with the federal charges coming up, I know a lot of focus is what's going to happen with these federal charges and how are they going to interact, so to speak, with the state charges? Do you think he could get more time with the federal government, and could that time run consecutive or concurrent? What do you think?
Well, it's important, Brian, as you pointed out in the package, that these are going to be civil rights violations. He's not being tried directly for the murder. And what generally and typically happens is, he's going to be serving his 15 years in state court out of his 22.5-year sentence. And then he would be, if he was convicted on these federal charges, he would then be moved to a federal jail to serve his time. His trial probably won't even take place till next year. And he'll obviously be moved from state jail to federal custody in order to sit through his trial. But once he's convicted, if he's convicted on federal charges, after his state sentence is over, then he will serve in a federal jail.
Now, question for you, Sue-Ann. When I was there in Minneapolis when he was being sentenced, he gave almost like a very cryptic message to the family, a very short condolence, but said that maybe in the short future that they'll get something to give him a peace of mind. What did you make of that message? Did it maybe shoot off any bells in your ears as to what he might be thinking about?
To me, I think that his statement didn't give the remorse that you're looking for at that stage, after a conviction's already been done, after there's a video showing what occurred. You know, the family is looking for remorse. They're not really looking for cryptic statements or, you know, I'll get back with you later. And that's kind of how his statement read to me. It was kind of like a teaser, like more to come, which at this point, the family's already been through so much that I don't think it worked in his favor. I get it. He has federal charges pending. They're different charges, and he may be assessing and weighing in his mind if something that he says at sentencing is going to affect him in his federal case. I get it. But I think that if you're going to bother to stand up there and talk to the family, that you should do it from the heart and show remorse.
Absolutely. I know a lot of people had similar criticism about his mother's impact statement, making no reference to the Floyd family and only talking about her favorite son. Thank you, Sue Ann. When we come back, Durst has had enough and breaks his silence in the middle of court. His words to the judge and prosecutor. And Douglas Durst takes the stand. Welcome back. Testimony was resuming in the Robert Durst trial, but before the jury was brought in, the real estate heir made his voice heard. Robert Durst is charged with murdering his best friend, Susan Berman, in December 2000. Investigators say Durst killed Berman because she was a witness to the still unsolved 1982 disappearance of Durst's first wife, Kathy. Defense attorneys for Durst says he's innocent and is suffering from failing health, including bladder cancer. Prosecutor John Lewin has accused Durst of exaggerating his condition to gain sympathy from the jury. He's also personally helped Durst change his catheter bag during breaks in court. Durst says he wants his catheter taken out.
Lewin is incorrect. I am not seeking sympathy from the jury. My head is shaved. This is the only kind of haircut that I'm able to get in the jail. In terms of this whole thing about my seeking sympathy and trying to harm myself with my catheter bag, I have been doing everything possible to get the jurors, to get the doctors at CTC to remove the bag. I don't want to have the catheter at all.
Terry, I think for Durst, that's a bit of an outburst for him, considering how much strength or lack thereof he has. What did you think about him speaking out in court and what he said to the court?
You know what, Brian, this is the most bizarre trial I have ever seen. The fact that he just stood up and said, can I say something? And then he's trying to explain that he's not faking anything. And it was just to really confront what Lewin has been saying all along. Very interesting. I don't think it's going to make that big a difference at all in this trial.
Yeah, and of course, this was before the jury was brought in. And then we also know that his brother took the stand. Any inclination as to what you heard from the brother that may have helped the prosecution or maybe even helped the defense? But you know what? First, before we get there, now to testimony in the trial, Robert Durst's brother, Douglas, took the stand and says he was aware that Kathy Durst was trying to file for divorce. He denied rumors that he was involved with Kathy's disappearance.
Do you have any knowledge of what happened to Kathy?
I have no knowledge, no.
Did you have anything to do with her disappearance?
Absolutely not.
Do you have any knowledge that your father had anything to do with her disappearance?
Absolutely not.
Did you have anything to do with covering up whatever Mr. Durst might have done to her?
I find that a very insulting question, but no, I did not.
And are you aware if your father had any involvement in allegedly covering up?
I have no knowledge of it, and I also find that insulting.
The real estate heir's brother went on to say that he feared the defendant testifying about death threats he received.
Were you afraid of your brother?
Yes, I was, because my brother, when he gets angry, he gets extremely angry.
Has your brother indicated how he feels about you to this day?
Yes.
And what are those feelings?
He'd like to murder me.
And are you aware of your brother, in fact, making calls from Pennsylvania discussing that very subject?
I am aware of that, yes.
Did you take those, and this is a yes or no question, do you take those threats seriously?
Yes, I did.
All right, Terry, let's get right into Douglas Durst here. Lewin starting his death by 1,000 questions technique. How was Doug Durst's testimony in terms of tying up all the loose ends for Lewin?
You know what, Brian, you hit it right on the head. Lewin asked a million questions. He started from the beginning and went to the end. And I think Douglas Durst did a fantastic job establishing everything Lewin needed to have established. Those main points include the fact that the brothers did not like Durst. They all feared him. They thought that Robert Durst was going to kill them. And that is the most strangest testimony to hear from a brother. And Douglas Durst also said he wasn't even invited to his brother's wedding, and that, they chose him over Bob to run the company, and that was bad blood between them, and that no one really liked Bob, and that he was, lying about the father. He said the father was strict and overbearing, when in fact, Doug confirmed that the father was a wonderful father. And he lied about the mother. All along, apparently, Bob Durst has been saying that he was made to watch his mother fall off the roof. And in fact, that's not true. So I think that Douglas Durst overall was an excellent witness. Lewin was able to establish everything.
Yeah, this seems more like a story of Cain and Abel rather than modern-day brothers. But thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.